Question number 46 contains 4 statements and we need to identify that which among them is the purpose of adjournment motion. So let us understand the meaning of adjournment motion. Now the literal meaning of adjourn is to postpone, and this information alone is enough to solve this answer. However, let's discuss the meaning of adjournment motion. Now the primary object of an adjournment motion is to draw the attention of Lok Sabha to a matter of urgent public importance which has serious consequences. Also, adjournment motion is required as a motion or a resolution with proper notice would be too late. Now in light of this information, it is very easy to point out our final answer, which will be option A, that is to allow a discussion on a definite matter of urgent public importance. Hence, our final answer would be option A. Please also have a look at the explanation. Question number 47 gives us 4 definitions of rights and we need to identify the correct one. Now in this context, understand the meaning of rights. Here, the right is referred to the fundamental rights which are enshrined in the Part 3 of the Indian Constitution from Article number 12 to Article number 35. Now these rights are provided by the Constitution to the citizens so that the state shall not trample upon any basic rights of an individual. However, these rights cannot be considered as privileges. Now in light of this information, the correct option would be option C, that is, rights are the claims of citizens against the state. Now, option B also sounds correct, that is, rights are incorporated in the constitution of a state. However, they are not considered as privileges. That is why option B will be incorrect. So, our final answer is option C. Please also have a look at the explanation. Question number 48 reads that which of the following statements is not a reason for conducting elections in India? Let us directly go to the statements. Now the first one says that elections enable people to judge the performance of the government. Now this is absolutely correct. That is, it is one of the reasons for conducting elections. Why? Because every citizen who is above 18 is given a right to vote. And the value of one person is equal to one vote. Hence, citizens have a great power in their hand and they can, by the means of elections, judge a performance of the government, and if they are not satisfied, they can remove the current government. Hence, statement 1 is correct. The second statement says that people select the representatives of their choice in an election. Now there's nothing to discuss about it, as we know that this is a provision. We do select our representatives in an election. Now the third statement says that elections enable people to evaluate the performance of the legislature, executive and judiciary. Now under the separation of powers, judiciary plays no role in the electoral politics or in this context elections. Hence, we know that statement C is incorrect and it is going to be our final answer. Let us also discuss statement D. It says that people can indicate which policies they prefer. Now this is again a correct statement, as citizens can indirectly influence policy making. Hence, this statement is also correct. Therefore, our final answer would be option C, that is, judiciary plays no role in elections. People can only evaluate the performance of legislature and executive. Please also have a look at the explanation. Question number 49 contains 2 statements and we need to identify that which among them are correct. Now, both the statements are pertaining to fundamental rights and they are covered under Part 3 of the Constitution from Article 12 to Article 35. Now the first statement is pertaining Article 21, which says that every citizen has a right to protect his or her life and personal liberty. Now the statement reads that the Constitution of India recognizes the right to water as a part of right to life under Article number 21. Now, Article 21 got wide interpretation during the Menaka case, and subsequently Supreme Court declared many rights as a part under Article number 21. Now, under this wider interpretation, Supreme Court held that Article 21 should be available not only against arbitrary executive action but also against arbitrary legislative action. Further, it also held that under Article 21 there should be provisions for right to live with human dignity, right to decent environment, which includes pollution-free water and protection against hazardous industries. It also included right to livelihood, the recently added right to privacy, right to shelter, among many others. Now, coming back to our question, we can see that the statement 1, which says that India recognizes right to water under right to life, is a correct statement, as we just discussed this. Now we can see that even the second statement is pertaining to the right to decent environment, wherein pollution-free water and protection from hazardous industries along with good air is given as a provision by the Constitution. Hence, both the statements are correct and our final answer would be option C. Please also have a look at the explanations. Question number 50 contains two statements and we need to identify that which among them is or are correct. Now the first statement reads that the concept of access to justice highlights the role of PIL, that is public interest litigation, in facilitating justice. Now this is a correct statement. Let's understand how. Now, the introduction of public interest litigation was done to move away from the traditional rule that the person whose rights are infringed alone can move to the court for remedies. However, under PIL, any public citizen or a social organization can move to the court for the enforcement of the rights of any person or group of persons who, because of their poverty or ignorance or socially or economically disadvantaged position, are themselves unable to approach the court. Hence, in this context, the scope of access to justice was widened under PIL, and this statement is correct. Coming to the second statement, it reads that the final interpreter of the Constitution is the judiciary, because they have the power to strike down any particular law passed by the Parliament if the judiciary believes that they are the violation of the basic structure of the Constitution. Now this statement is also correct because under the Keswanand Bharti versus State of Kerala case, the Supreme Court ruled that the basic structure of the Constitution is inviolable and could not be amended by the Parliament. Therefore, our final answer would be option C, that is, both the statements are correct. Please also have a look at the explanations.
Question number 51 is in respect to the Pradhan Mantri Gram Sadak Yojana. Now this scheme is important because it is a flagship scheme for rural development in India, and UPSC in the past years has been asking questions on flagship schemes of the various ministries. The PMGSY is the flagship scheme of the Ministry of Rural Development. The aim of the scheme is to provide connectivity to the remote and unconnected areas in the country via an all-weather road. An all-weather road is a road which is operable throughout the year. The unit for PMGSY is a habitation. Please keep in mind that this scheme shall cover only the rural areas in the country. The scheme envisages a single road connectivity. A single road connectivity means that if a habitation is already connected by way of an all-weather road, then no new work can be taken up. Now coming to the question, the first statement the unit for this program is a habitation and a revenue village is incorrect because as we have seen, the unit is only a habitation and not a revenue village. Secondly, PMGSY shall cover only the rural areas. This is correct. Third, PMGSY envisages only a single road connectivity. This too is correct. Therefore, the right answer to this question is A, 2 and 3. Please look at the explanation for further information on this scheme. Question number 52 is with respect to the powers of governor under the 5th schedule of the Indian Constitution. 5th schedule is very important from the perspective of UPSC because very recently the cabinet has decided to expand the scheduled areas under this 5th schedule to some areas in Rajasthan. Let us look at it in detail. The first thing that you should know is that Article 244 of the Indian Constitution is talking about administration and control of certain designated areas which are called the scheduled areas and the tribal areas. The Article 244 mentions about the 5th schedule and the 6th schedule of the Indian Constitution. The 5th schedule deals with the administration and control of the scheduled areas and the scheduled tribes in any state of the country except 4 northeast states of Assam, Mizoram, Tripura and Meghalaya. The 6th schedule, on the other hand, talks about administration of tribal areas in only these 4 northeast states of Assam, Tripura, Mizoram and Meghalaya. Now, under the 5th schedule, it is the President who has the power to declare an area as a scheduled area as well as the power to alter the boundary of such area. Further, each state under the 5th schedule has to establish a state tribal advisory council whose function is to look into the welfare of such scheduled areas. Under the 5th schedule, the governor has the power to declare that any act of parliament or state legislature shall not apply to such scheduled areas. Now, under the 6th schedule, all the tribal areas in these 4 northeastern states have to be constituted as autonomous districts. Now, these autonomous districts shall have district councils which will administer such areas. Now, though these district councils do have the power to make laws, but such laws shall require the assent of the governor. The 6th schedule also mandates that the governor is empowered to organize and reorganize the autonomous districts constituted under this schedule. Now, coming back to the question, the first statement reads, the governor is empowered to direct that any particular law of the parliament or the state legislature does not apply to a scheduled area. This statement is correct. Second, the governor is empowered to organize and reorganize autonomous districts. Now, you have to be very careful that this power of the governor is given under the 6th schedule and not the 5th schedule. Therefore, though this second statement is correct, this becomes wrong in the context of our question, which is asking statements only with respect to the 5th schedule. Third, laws related to matters like land, forest, shifting cultivation, etc. require the assent of the governor. This statement is again wrong because such power is given under the 6th schedule. Thus, your correct answer would be A, 1 only. You can refer to the explanation for further clarifications. Question number 53 focuses on the special status provided to the Union Territory of Delhi. This question has been framed because recently the AAP government has started a full-fledged campaign for complete statehood for Delhi. Now, the 69th Constitutional Amendment Act 1991 granted a special status to the Union Territory of Delhi, under which it was redesignated as the National Capital Territory of Delhi. This act provided for a legislative assembly for the National Capital Territory of Delhi. Under the act, the Chief Minister and other ministers shall be appointed by the President of India. The Act stated that the executive head of the Delhi would be a Lieutenant Governor. It also said that the Lieutenant Governor would have the power to refer any issue to the President on which the Council of Ministers differ. The first statement of the question, the 70th Constitutional Amendment Act provided special status to the Union Territory of Delhi, is wrong because we have seen it was the 69th Constitutional Amendment Act. Second, the Chief Minister of the Union Territory of Delhi is appointed by the Lieutenant Governor. This is also wrong. The Chief Minister and the other minister are appointed by the President. Third, Article 239AA empowers the Lieutenant Governor to refer to the President any issue on which there is a difference of opinion with the Council of Ministers. This statement is right. Therefore, your correct answer is C, 3 only. For more information, please look at the explanation. Question number 54 asks us to consider 3 statements with respect to the Swadesh Darshan scheme. The Swadesh Darshan scheme is important because it is a flagship scheme in the tourism industry of the country. The scheme was launched by the Union Tourism Ministry with the aim of increasing tourism in India. The scheme intends to develop theme-based tourist circuits all across the country. Please remember that this scheme is a 100% centrally funded scheme. Unlike other schemes, the share of funds under this scheme shall vary from state to state. Coming to the question, the first statement reads, this scheme was launched by the Ministry of Road Transport and Highway, identifying thematic circuits across India in 2014-15. This is wrong. It was launched by the Union Tourism Ministry to develop theme-based tourist circuits. Second, it is a 100% centrally funded scheme. This statement is correct. Third, funds for the scheme are uniform across all the states. This is wrong. We have seen that the funds vary from state to state. Hence, your right answer would be D, 2 only. Please look at the explanation for more information. Question number 55 is asking us to consider statements with respect to the special category status for various states in the country. The special category status has been a burning issue since recently. States like Andhra Pradesh and Bihar have been asking for such status as well. Let us know a few things about it. There are certain states in India which are at a disadvantage due to certain inherent features because of which they are not able to develop to their full potential. Now, when such states get the special category status, they are provided with a preferential treatment in the form of central financial assistance and tax breaks. Now, this concept was introduced in 1969 by the 5th Finance Commission. Therefore, please bear in mind that there is no mention of special category status in the Constitution of India. Now, for a state to be recognized as a special category, it needs to have certain features. Firstly, it should have a hilly or a difficult terrain. Second, it should have low population density. Thirdly, it should have a strategic location along the borders, or it can be economically or infrastructurally backward, or lastly, it can have non-viable nature of state funds. Now, one of the major advantage which a state gets when it is a special category state is that in a centrally sponsored scheme, central government will pay 90% of the funds, in contrast to the central government paying only 60% of the funds in case of a normal state. Now, the first statement reads, the center pays 90% of the funds required in a centrally sponsored scheme to special category status states as against 75% in case of the normal category states. This is wrong. As we have seen, the center pays 60% in case of a normal category state. Second, criteria for SCS are hilly terrain, low density, location along borders, economic backwardness, which is a correct statement. Therefore, the right answer to this question would be B, 2 only. Please have a look at the explanation for more details. Question number 56 is with respect to the safeguards provided for minorities in India. The cultural and educational rights of minorities in India is important because they were a subject matter of a recent Supreme Court judgment. Article 29 and 30 talk about cultural and educational rights given to minorities. Both of them are part of the fundamental rights. Article 29 states that any section of citizen residing in the territory of India and having a distinct language, script or culture shall have the right to conserve the same. Subclause 2 of Article 29 further states that no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. On the other hand, Article 30 says that all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. Subclause 2 of Article 30 says that the state shall not discriminate any minority-based institutions in respect of granting aid to it. Coming to the question, the first statement reads, Article 29 of the Indian Constitution empowers all minorities to establish and administer educational institution of their choice. This statement is wrong. As we have seen, this right to establish and administer education institution is given under Article 30. Second statement says, Article 30 of the Indian Constitution empowers any section of citizens residing in the territory of India to conserve distinct language, script, and culture of his/her own. This statement is again wrong because this right is provided under Article 29. So as we can see in this question, basically the article numbers have been swapped. Therefore, the correct answer would be D, neither 1 nor 2. Kindly refer to the explanation. Question number 57 is giving us 3 statements with respect to Article 25 of the Indian Constitution. The fundamental rights of which Article 25 is also a part of are one of the core areas of polity in the UPSC. Also, since recently the right to freedom of religion was highly debated in the Sabrimala issue, this article is of importance. Now let us look at its provisions. As stated, Article 25 guarantees the freedom of religion. Under this article, all persons, and not necessarily just citizens, have the freedom of conscience and the right to freely profess, practice, and propagate one's religion freely. But all these rights and freedom are subject to 3 limitations of public order, morality, and health. Now, under Clause 2 of Article 25, the state can make laws, firstly, to regulate and restrict any economical, financial, political, or secular activity associated with a religious practice. Secondly, the state can also make laws for social welfare and reform, wherein it can throw open Hindu religious institutions of a public character for all sects and sections of the Hindus. Now coming back to the question, the first statement reads, Article 25 covers religious beliefs as well as religious practices. This statement is correct. Second, rights under Article 25 are available to all persons, citizen and non-citizen. This is also correct because we have seen the wording of Article 25 is all persons. It doesn't mention citizen. Thirdly, rights under Article 25 are subject to public order, morality, and health. This is also correct. Therefore, the correct answer to this question would be D, 1, 2, and 3. You can have a look at the explanation as well. Question number 58 is in the context of the National Commission for Minority Education Institution, NCMEI. The NCMEI is important from the UPSC perspective because recently the Supreme Court has held that NCMEI has original jurisdiction to determine which institutions in India should be granted with minority status. Now let us look into a few details about this. The NCMEI comes under the Ministry of Human Resource Development. The commission was set up in 2004 via an ordinance. Later, in the year 2005, the NCMEI Act was enacted, whereby this commission became a statutory body. The main mandate of this commission is to look into complaints regarding deprivation or violation of rights of the minorities to establish and administer an educational institution of their choice, which is also a fundamental right guaranteed to them under Article 30 of the Constitution. As far as the composition of the commission is concerned, it is headed by a chairman who has been a judge of a high court plus 3 other members, all of which are nominated by the central government. The NCMEI is a quasi-judicial body endowed with the powers of a civil court to seek compliance to its order. Now coming back to the question, the first statement reads, it is a statutory body which comes under the Ministry of Home Affairs. This is a wrong statement. It comes under the Ministry of Human Resource Development. Second, the commission is a quasi-judicial body and has been endowed with the powers of a criminal court. This is wrong. It is endowed with the power of a civil court. Therefore, the correct answer to this question would be D, neither 1 nor 2. Please have a look at the explanation as well. Question number 59 has been framed in the context of the Personal Data Protection Bill 2018. This bill is very important because it is the first specific law on data protection in the country. Also, because right to privacy, which has been recently held to be a fundamental right, is incomplete without having the right to protect one's data. Now, the bill has been drafted by Justice Sri Krishna Committee. The bill seeks to have efficient enforcement through a data protection authority. The bill has also laid great emphasis on the rights of individuals as well as the obligations on data fiduciaries. The bill has also differentiated between personal data and sensitive personal data. The bill has also mandated for data localization, which means that one serving copy of the data has to be stored in the country. Under the bill, a lot of restrictions have been imposed on the cross-border data transactions, that is, transferring of the data to other countries. The bill also provides for offences and penalties in case of violations of the rules. The bill is applicable to the state entities, corporate entities, as well as Indian citizens. The first statement of the question reads, the Personal Data Protection Bill 2018 applies only to private entities. This is wrong. It also applies to government entities. Second, the bill places restrictions and conditions on cross-border data flows, which is correct. Hence, the correct answer to this question is 2B only. Please refer to the explanation for more information on the bill. Question number 60 has been asked in the reference to the Rashtriya Gram Swaraj Abhiyan. This scheme is important because it was recently launched by the Prime Minister of India on the occasion of National Panchayati Raj Day, which is celebrated on the 24th of April. Now, the RGSA is the flagship scheme of the Ministry of Panchayati Raj. The scheme is a revamped version of the Rajiv Gandhi Panchayat Sashaktikaran Abhiyan. The scheme is funded by the central government and it aims to develop the governance capacity of the Panchayati Raj institutions so that the Panchayati Raj institutions can deliver on the Sustainable Development Goals of the United Nations. This scheme shall extend to all states and union territories in India. The first statement of the question is, it is a revamped version of the Rajiv Gandhi Panchayat Sashактикаран Abhiyan, which is correct. Second, it is a central sector scheme which aims at making rural local bodies self-sustainable, financially stable, and more efficient, which is also correct. Hence, the right answer to this question is C, both 1 and 2. For more details, please look at the explanation.